Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about the particularities of E-2 investor visa for Australian citizens. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. The E-2 visa is a non-immigrant visa for the United States that allows Australian citizens to invest a substantial amount of capital in a US business and come to the United States in order to develop and direct the US business. In order to qualify for the E-2 investor visa, Australian citizens can start a business in the United States from scratch, or they can purchase an existing business or franchise. The purchasing of business can also occur through a purchase of assets of a business, not only purchasing percentage ownership in a business, in a US business. Australian investors who are applying for an E-2 visa will also be able to bring managers, executives, and specialized knowledge employees that are essential to the operation of the US business to the United States on an E-2 visa, as long as the employees also hold Australian citizenship. Also, E-2 visa holders will be able to bring their spouse and children under the age of 21 and unmarried to the United States on an E-2 visa. The spouse will be able to work in the United States, and their right to work in the United States is unrestricted, meaning that spouses of E-2 visa holders will be able to work part-time or full-time in the United States, be self-employed and start their own business, or even work for the E-2 business if they choose so. The E-2 visa for Australian citizens can be granted for 5 years, the maximum period allowed under the treaty between the United States and Australia. The E-2 visa can be renewed indefinitely as long as the business is successful. For the E-2 visa, you will have to pay the regular E-2 visa fee, which is $315 per person, and an additional $5,592 for the reciprocal fee. Now, who can apply for the E-2 visa? Australian citizens can apply for the E-2 visa under the treaty between Australia and the United States. This means that if you do not have an Australian passport and you are a permanent resident of Australia only, then you will not be able to apply for the E-2 visa under the treaty with Australia. However, if you have a passport from an E-2 treaty country, then you will still be able to apply for an E-2 visa, but under the treaty with your country of citizenship. Australian citizens must meet the following E-2 visa requirements in order to apply. 1. The investor has invested or is in the process of investing in a US business. For those of you Australian citizens who are purchasing a business or franchise, the purchasing price qualifies as irrevocable investment for the purpose of obtaining an E-2 visa. However, for those of you who are applying with a new business for an E-2 visa, the investment will be the money you spend on setting up your startup. So investment will be calculated based on expenses that go towards premises, technology, salaries if you hire US workers prior to your E-2 visa application, any marketing expenses, equipment, inventory, and any other expenses you have in order to start your business in the United States for obtaining an E-2 visa. Now, keep in mind that the investment must be at risk at the time you are applying for the E-2 visa. So the capital you invest in the US business cannot simply sit in a bank account in the United States. They need to be irrevocably committed to the US business in order to be able to qualify for the E-2 visa. So you must have them at risk of losing your entire capital or part of the capital and the investment you've made if the business doesn't succeed or the E-2 visa is not approved. 2. The business is real and operating. This means that the US business you are investing in produces goods or services that it offers to the public and is not simply a passive investment such as a company that will hold real estate or stocks and bonds. 3. The capital you invest must be substantial. So you must make a substantial investment in a US business. Now, there is no set amount of what constitutes substantial investment when it comes to the E-2 visa. But basically, you need to invest enough capital to give the company a good chance to succeed, and also invest enough capital in order to be able to either start the business or finance the operation or an expansion, or enough money to cover the purchasing price of a US business. However, the amount that will be considered substantial really depends on the nature of the business and the location of the business. So for example, while $60,000 may be considered substantial investment when you are investing in a consulting business in the United States to start a consulting business in the United States, the same $60,000 will not be considered substantial if you are looking to actually start a restaurant in Los Angeles, for example, or Miami, or New York, or Chicago, or you are looking to start a hotel or some manufacturing facility. So what the capital is substantial, how do you decide if the capital is substantial, really depends on the nature of the business and the price of the business and the location and either the price to purchase the business or the startup cost for the business. For business is not marginal. Another requirement that you must meet at the time you apply for the E-2 visa is that the US business is a viable business, meaning that it has the potential in the future, and with the startups, that means over a 5-year period, it has the potential to generate income in order to hire US workers and contribute to the US economy by paying taxes and creating jobs in the United States. And it's not simply a marginal business that only generates revenue enough to cover you and your family's expenses in the United States in order to simply live in the United States. So definitely the business at the time of application must have this potential to generate income to hire US workers and not simply cover your living expenses in the United States. And finally, 5, you must have an intent to depart the United States once the E-2 status terminates. This means that you must intend to leave the United States when the E-2 status ends and not stay in the United States illegally. However, you are still allowed to apply for an E-2 renewal or to extend your E-2 status. So just by having this intent to leave when the status terminates does not mean you cannot apply for renewal or extension of your E-2 status. As long as your business is operating, you can always apply for an E-2 extension or an E-2 renewal or even a new E-2 visa again. Now, the E-2 visa application process for Australian citizens. So once you've made your investment and the E-2 visa application package is ready, you can submit it to the US consulate in Australia. After they receive the application package, the US consulate will review your application, your E-2 visa application, and once they are ready to interview, they'll invite you for an in-person interview, and you will need to attend this E-2 visa interview in person at the US consulate in Australia. Now keep in mind there is no expedited processing when it comes to E-2 visa applications. Also, another point to mention, you cannot apply for an E-2 visa from the United States. If you are in the United States, you may be able to apply for an E-2 status if you have entered the United States on a visa. So if you are in the United States on an ESTA, then you will not be able to apply to change status to E-2 in the United States. But if you have entered the United States on a visa such as B1, B2 visa, then you may be able to apply for a change of status to E-2 in the United States. However, the E-2 status you obtain in the United States through change of status through the United States Citizenship and Immigration Services is not the same as holding an E-2 visa. The E-2 visa for Australian citizens can be issued for a maximum period of 5 years, and the visa stamp is an entry document and will allow you to travel in and out of the United States as you wish over the course of its validity, over the 5-year period. With the E-2 status, the E-2 status you obtained through the United States Citizenship and Immigration Services through a change of status can be issued for maximum of 2 years, and that is not an entry document. So it is only valid as long as you stay in the United States. The moment you leave the United States, you cannot use that E-2 status from USCIS in order to re-enter the United States. Instead, you will have to go and apply for an E-2 visa at the US consulate abroad and obtain an E-2 visa stamp in your passport in order to come back to the United States. Keep in mind that you can renew your E-2 visa indefinitely as long as your business is successful. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.